The views and opinions expressed do not necessarily represent those of Access Fort Wayne, the Allen County Public Library, or any other supporting group. If you or anyone you know might be interested in making a television show, please call 260-421-1250. Access Fort Wayne is a department of the Allen County Public Library.
All right, well, welcome everyone. How's everybody doing? Yeah, that was a great reaction. So slow, but we got there. So my name is Becca Brooker, and I am the Assistant Executive Director at the Volunteer Lawyer.
You always post a notice to the front door. Give them 7 days. I'm looking to see if you're still living here. Give me a call. And if they call you, you have your answer. And if you don't, that's just one more thing that would point towards a tenant having actually abandoned the property.
So if the tenant and the landlord are in a lease at that time, they believe that the property is abandoned, do they need to have a court action, or can they just move forward with having possession of the property back?
So typically, you'd be able to take possession of the property. Reasonably believe that a tenant has vacated a property, you wouldn't have to file an eviction, at least in the state of Indiana. So if you are outside the state of Indiana, it'd be different. So that's
Okay. Anybody else want to add anything?
I would say, at least from the court's perspective, you might want to be real sure that you believe that it's abandoned. Because if you don't, then the tenant can come back and file something to get back into the home or the apartment, whatever it is. A lot of times we'll see it as an example. Someone goes to jail, their property may or may not still be in the house, the apartment, but maybe the rent's being paid. Maybe it's not. And you just, as a landlord, you haven't been by there in a while and you just don't know. And you try to contact the person and their cell phone's off, or it's been changed, or you can't get a hold of somebody. So the issue of abandonment is an important issue. We know it happens out there, but I would say talk to an attorney, right? That's number one. Number two, but be very sure before you start turning off utilities, especially if it's not in your name, changing the locks. If there's any sort of property in there, you just run the risk of doing something that you could be held liable for, as far as, like, say, punitive damages and things like that. I'm going worst case scenario, okay, but just as a safe bet.
Right. What requirements are there for a landlord to act as warehouseman? I assume that means holding onto the property.
Well, I think that's going to go. I'll take it since everybody's looking down this way. I think that's going back to the abandonment issue and how I'm interpreting the question a bit. And I want to tack on something my fellow panelists here said, is that it's intent. What you're looking at is intent. And what the court is going to look at is all those facts. There's never going to be a bright line rule. Hey, if there's cheese in the drawer, they abandon it, or something like that. So what I want to know from my clients when they bring up that question is, why do you think it's abandoned? What's in the house? Tell me things about it. I'm probably suggesting to my clients to file an eviction in cases where they think there's abandonment. I'm of the school, an ounce of prevention is worth a pound of cure. So I'm telling my clients, let's file an eviction. That gets your clock moving on that warehouse issue. I think that most of the time what I'm telling my clients is reasonable time, and everybody wants to know the reasonable time. There is no number. I think 2 weeks is sufficient if you have good contact with them. If you don't have good contact, you're going to need to show Magistrate Douglas or one of the other magistrates that you went through your best efforts to get that property back.
Are you talking about the abandoned property procedure?
It does not. I read it as it's written.
Okay, in the packet that you have in front of you, on one of the pages, it does outline the process in Allen County specifically for if a tenant vacates a property and leaves personal property behind. There is a local rule here in Allen County. I would definitely suggest following what that local rule says, because failure to abide by that could result in liability to the landlord. for the cost for that tenant to replace those items if you did, one, either prematurely throw things away, or two, you didn't follow the very detailed local rule, the process that's set in that.
Yeah, I'll echo that statement. I don't know what's on that sheet, but it's 14 days. So, for example, if a tenant moves out or they left and you have an order for possession and there's property left over, you have 14 days as a landlord. You have to keep that reasonably safe. Whether that's in, what we see a lot is most times the landlord just keeps the property in the house in the apartment. Sometimes they do move it to a storage unit or some sort of storage closet, as they may call it, or some sort of locked, secure room or facility. But you have 14 days, so you have to keep it for 14 days. And then after that, then you can dispose of it. And as Logan pointed out, he's absolutely correct. There is a local rule here in Allen County, which I'll put a plug in for the local rules. Please read those if you haven't had a chance to. They're on the website, on Allen County Clerk's Office, Allen County Superior Court, and every county. I don't know if anybody in here does anything in other counties, but I would suggest that whatever county you're in, whatever you're doing, typically they have local rules. Now, they might not have landlord-tenant, but I would double check. But overall, you have 14 days to make sure that property remains reasonably safe. Or you could be held liable for the fair market value, which, just so people know how the court perceives fair market value, without any additional proof, is garage sale value. Okay, so that's kind of that's how we determine that.
Awesome. That clears that up. I was really shaky in the beginning, but good. This one is a three-part question. So, how do landlords deal with someone who is residing in the property and not on the lease? And I'd like to know, is that 14 days in a calendar year that you have someone stay without them being on the lease?
Usually that's determined by the lease itself when they do that. But various leases will have those provisions saying, hey, you can only have a guest for 14 days or 7 days. And as long as that's reasonable, I've always seen it being upheld by a court. So that is by the lease.
What if it's not in the lease?
Then it can depend. It might depend on, for instance, the relationship between the people who are there. How long have they been there? So it would be very fact specific, I think, as to why they're there. Sometimes, for instance, like a boyfriend or girlfriend is probably the most common example. Might have a falling out and won't tell the other to leave. They're never on the lease. And it might depend. Did the other person who's being asked to leave pay rent? Did they do anything that makes it look like a tenant relationship? So it might just matter, have they done anything that makes them look like a tenant, even though it's not a lease?
Okay. Oh, I thought you had.
I agree with Andrew on that, but generally that would be what's called an unauthorized occupant. You should have a provision in your lease agreement that states what happens when you have an unauthorized occupant and what you can do after that. You find out.
A lot of times the leases will have a clause in there where it says you got to have written permission or written agreement. If it's not in the lease, or written agreement by the landlord and the tenant to allow some other person to come on, or some process to add into the lease. And if it's not in the lease, what the court kind of looks at is, like, I may have, my mom lives out of state, so she may come and stay with me for 2 weeks for vacation. It doesn't mean I got to evict her. I mean, I don't have to come down and file a case to evict her. Now, if my mom says, hey, I need a place to live or stay, which is always a common distinction in court, right? I stay there, but I don't live there. Oh, okay. But if she's there for 1 day and she's got all of her stuff and she has her own room and she's doing all these things, she can make a claim that, no, I live there. We talked about it and I've been here for 1 night. And that may be sufficient. So to piggyback what Andrew said, it's very fact sensitive.
But that is something that needs to be covered in the lease, because if it's not in the lease, then they can have whoever they choose to.
Can I speak for the
gray areas with this?
I'd like to speak for the panelists here, and I'll tell you guys, 90% of your problems will be fixed by a better lease.
Yes.
Every single time I get a landlord in my office, with an issue, I say, first question, let's look at the lease. That question's answered by it being in your lease. Don't get one off of Google, please.
Can I ask, is there a standard where they can get a standard lease that covers all of these topics?
I'll write one for you.
Yeah, I was going to say, it's funny when I was originally thinking about this conversation, I thought, how many times are we probably going to come back around to, you know, our job or your job, even if you're representing yourself as a landlord in a situation, it all comes down to documentation. Everything does. We fight through evidence and documentation, whether it be pictures, notes, texts, emails. Conversations are great. We don't want to lose that relationship aspect, but you always have to cover yourself, and it starts with your contract. So it's not that you can't get online and find a good contract. A lot of times, maybe that is a good starting point to read through some of the language, but don't go with your first one that's 8 pages long and it sounds like it has a lot of legalese, and so surely it covers everything, because inevitably, and maybe you say, well, I've been a landlord for the last 20 years and I've never had an issue with my lease that I've used. There will come a day where, if it hasn't already happened, that you're going to have a situation. And a lot of times it's like Jacob said, it literally comes down to something was missing, something was misinterpreted, something wasn't documented. And as wonderful as our magistrates are, they're only able to go and render a decision if you end up in a court situation based off of what you're able to present and prove. And so the more you can cover yourself in any of these topics, the better. And you hate to say that you've got to sort of carry that with you, because we're all busy and there's a lot going on. But if you can just take that little extra time to make sure that your document, or pay that a little bit of extra money to someone who does that on a regular basis, it'll be worth it.
Could they get a lease from an attorney without having to hire an attorney regularly?
You mean like use a lease for multiple properties?
Well, can I call you and say, hey, can you create a lease for me for my properties, a general one, but I don't want to hire you to evict all my tenants because I really can't afford that? Yeah.
I could probably answer
Yeah.
There are some offices out there that might have a lease agreement, ours included, that we have poured a lot of time into, just knowing how the landlord kind of business works. You can always reach out to a firm to see if they have a lease agreement that you could purchase off of them. A lot of them may have a lease agreement that could be affordable for you. A lot of times that also comes with, hey, we'll give you this for a cheaper price. You do whatever you want with it, and we'll take a look at it to see what you added, or if there's anything that you put in there that might be amended a bit.
And I'll just piggyback there. I'm telling my clients, hey, I'll write you the first one. You use it for what you will. I will make no guarantee on the second go around. If you have questions, if this is something slightly different, call me. We'll spend 5 minutes on the phone. And I'll tell you how to fix that clause. It's just so much easier than down the road spending $1,000 for me to unwind that issue. And rather than 10 minutes of me to say, hey, change that word.
Like, make sure you have an attorney fees provision in your lease agreement. I think there's a misinterpretation a lot of times that, well, I'm in the right, I'm the property owner, and this is across the board in legal in general. But I think all of us run across it on the daily basis. I have a legitimate claim. I've proven my claim. I should be entitled to attorney fees. And unfortunately, that's just not the way it works. You have to have the ability to show that you have a legal provision that you can legally claim that. And not everything in law allows the winner to collect attorney fees. But something as simple as having language in there could allow that.
That's right. So you have to add, there's 2 ways you get attorney's fees: by statute, by law, or in a contract. If you don't have that, you don't get attorney's
You're paying your way.
You're paying your way.
Last thing I'd like to add before we go on, keep on this one. There are apartment associations out there. In fact, the Portland Apartment Associations are a great organization for any landlord to be a part of. I would always encourage anybody to reach out to them if you have questions regarding general items as well. And she is actually in this room today. So,
Hello.
For those of you who do land sale contracts, just let me quickly pull up this. That form is free. That form is standardized. That form you should use.
Okay.
Just if you're in the arena of land sale contracts.
There is an Indiana lease that's available through the Indiana Apartment Association, a company called Blue Moon, and they specialize in contracts, and they try to make them specific for the state. I still would recommend you have your attorney look at them though.
Okay. Thank you. Earlier conversation about the abandoned units or property. Does the 14 days apply to abandoned units or only when the rent is signed? And I'm sorry, it might be. Did everybody hear me?
No.
I'm so sorry. Does the 14 days apply to abandoned units or only rent?
For a lot of our clients, one of the things that I tell them when we talk to them regarding this is that no matter what the situation is with a tenant, they vacate, they get evicted, they abandon the property, that 14-day starts the day that you receive possession of the property back in every single situation, as long as that tenant has left personal property of value behind. That's what starts the whole process for that. But doesn't matter if it's an eviction, doesn't matter if you worked out an agreement with the tenant for them to vacate. It's every single situation.
Correct.
Okay, when seeking damages from tenant after tenant, why can I not charge for my labor performed at a fair rate when I fix and repair the property? So the landlord has to go over there and fix the walls and fix that, and that might be part of the damages, but that's not part of his labor or, the cost that he has to pay.
If he's doing the work in him or herself, we see it all the time.
Yeah, I would say document it.
We see it all the time where, when I say we, the court sees it all the time where someone comes in and we understand that landlord's goal is to spend less and to earn more. But it's routinely where landlords come in and say, I fixed this myself, I cleaned this, I cleaned out the refrigerator, I scrubbed the floors. And then you just have to put a dollar amount on that, or what I would say a reasonable dollar amount, right? And then the tenant could argue that it's unreasonable, and then the court would decide what that reasonable number is or should be. But yeah, no, routinely we see that often.
So I'd like you to do, if you're my client, I'd like you to keep a log of that. I went over on Tuesday and spent 4 hours, and this is my rate. And I'm going to put that in front of Magistrate Douglas. I'm going to say, hey, here's our summary of labor cost, and he's going to be able to look at that and say, this is reasonable, or no, Jake, you're trying to tell me it took you 3 hours to change a light bulb. He's going to be able to wade through that, but that makes a really good piece of evidence for that damages here.
And the other important distinction is to make sure that the repairs you're doing are things that are beyond normal wear and tear, that are actually caused by some behavior from the tenant. And because you're not just going to get damages for, just fixing everything in your house. It has to actually be connected to the behavior of the tenant. And the landlords very often get very disappointed in the cases I've seen when they don't get, the whole house painted and all the carpeting replaced. Because it might be an old carpet and it hasn't been replaced in a while, but that's not the tenant's fault. That's just normal wear and tear.
My leases do cover unlawful tenants. Indiana code says we can have them removed, but the police call it a civil and say we have to use the courts. How best to handle this?
Well, if you call the police come out and say, we're not going to do anything about it, then you're going to have to go through, what I would say is go through the normal process. I know from the landlord's perspective, I assume that it would be a pain and some costs associated with that. But if the police aren't going to do anything about that particular instance, then you're going to have to follow the normal eviction process. It's like, I'll use an example, a non-landlord example, where someone calls the police and they say, my neighbor, said F this and F that, and you're this and you're that. I want you to do something. They're going to go get a protective order. As an example, I'm not going to do anything. I'm not going to be arrested. I'm not arresting anybody. but go to civil court, go use the court system. So that does happen.
Okay? If it's not in the lease, is anyone required by Indiana law to give notice at the end of the lease, whether it's the tenant or the landlord? If there's no provision in the lease, that'll continue month to month automatically or something else.
Maybe. So for instance, if your tenant is under like subsidized housing, there very likely is a notice requirement of some sort. It might be a month, it might be something else. It depends on the program. If you just have no lease at all under Indiana law, you should give 10 days notice if it's for non-payment. And if it's just for you ending the lease, you should give a month's notice if there's no lease at all. But most leases, as we've already described, most leases will fix this issue and make clear on both sides what your notice requirements are.
Right. I want to make the notice is to vacate the residence. Like we're not renewing the lease, or we are renewing the lease, or what are we? Is that what the kind of the primary question was?
It was pretty much.
Okay.
Yeah. Because most leases will say this is how your lease will end or how it will renew. If it doesn't, it might just renew all of it. So if you're not careful with your lease, you might have an annual lease, but if you don't say anything, you may have just renewed the lease for another year, even though you didn't intend to do that. So you want to be careful on what is in your lease, because whatever's in your lease will control. If there's nothing, there's no lease at all about how to end it, the rule is a month's notice.
To add to that, kind of what Andrew said, that is very fact specific. Every single situation is going to be different. But I would add also that if you have a tenant that's on a month-to-month lease, it's typically 1 full month's notice if you're not renewing a tenant. So if you get to September 30th and you have them a notice, not renew, you can do the last day in October. You get to October 1st, you missed your deadline, you have to give them until the end of November at that point. For a non-renewal for month to month.
And the court is a stickler on that. We just are. But on the flip side, if you give that notice and they don't move out and you come to court, that's the only issue that you need to present. You gave the 30-day notice. I waited until the full 30 days because that's another thing too. Please, if you're going to give a 30-day notice, you have to give them that full time. You can't file your notice of claim during that period of time, because if you do, you'll probably hear me say, or one of my colleagues say, you filed this prematurely, and it's denied. So if you give the 30-day notice, give them the full amount of time. If the tenant doesn't get out on day 31, file your notice of claim, and that's the only issue that the court has to hear. There can be other issues too, but I mean, from the court standpoint, it's like you gave it 30 days, you weren't out. There's no defense to that.
And for those of you who haven't looked at your lease in a while, what I see most of the time on leases is at the end of the term, it renews at a month-to-month basis. I think that's 7 out of 10. So that's what these guys just said is super important for at the end of the lease, because you may have talk yourself into a month-to-month lease by your lease.
I would also just add, if it's a lease that says nothing, it might depend on the duration of the lease, on how much notice you have to give at the end. But 90% of the time, something in the lease tells you what that period is going to be by contract, and that'll override the other types.
You're a landlord, you give your tenant notice to vacate the property because you do not want to renew the lease. The tenant demands to know why. Do you have to give them a lease? Go ahead, Lindsay.
This also kind of encompasses with fair housing. For a non-renewal, at least in our experience with the court's purposes, you generally do not have to have a reason, as you have a contractual obligation with that tenant. They could give you a notice just like you gave them a notice of non-renewal. Now, with fair housing, I know we're doing that next time, but it's a good plug for that. fair housing, they are looking at non-renewals. There is a presumption out there sometimes that giving a tenant is presumed, tenant non-renewal may be presumed to be discriminatory for some reason or as retaliation. Retaliation is not just fair housing either, it's also part of the Indiana Code as well. So you should generally have a reason for non-renewal. The tenant causes a lot of problems with the house, and they're actually caused by the tenant, not something that the landlord's responsible for. There's a myriad of examples I could give for that. But in the end, generally, no, you don't need one, but you are encouraged to have one kind of in the back, in the file, something to base it off of if it ever does become a fair housing issue.
Asterisk. Just a warning, the big exception to this would be certain subsidized housing programs where you have to show good cause for that to do. We could go on for an hour for that. Sometimes you do have to show good cause if you're subsidized housing.
Subsidized housing is a whole other wheelhouse. Deceased tenants. If there's multiple family members step forward and saying, I'm the responsible person, who do you know what to do with their stuff, their belongings, their deposit? How do you handle that?
All right. If I'm advising the client, I'm asking for some order. Generally, our Allen County courts are going to appoint a personal representative. I'm looking for something like that. That's going to give you, as landlords, some kind of protection to say, hey, I relied on this document. I turned it over to them. That's going to give you some protection. By and large, outside of that, I don't know how much protection you're going to get.
You can also go get a small estate affidavit. There is a process for that. So I encourage you to talk to an attorney if something like that happens. There is also part of the Indiana Code, the tenant designation or tenant representative. Every single landlord should be having their tenant complete that paperwork. It designates a person that tenant specifically designates that if in the position of that tenant becomes incapacitated or deceased, that other designated person would then become accept and to sign the acceptance of that, and then that person is who you would handle all of those things with. You still do the security deposit letter, and security deposit, all of that stuff with that designated person.
Is that covered in one of your leases, Liz?
It's an addendum. It is an addendum.
I tried to bug you. Can or should guardian tenants be named on leases?
I'm not sure what that question means. I'm not sure what a guardian tenant. Okay.
But if somebody has a power of attorney over another adult over the age of 18, according to that person can't, they're claiming that that person doesn't have the mental capacity to sign a lease or understand what they're signing, but they're over the age of 18, do they still get named on the lease, or are they just as an occupant?
Good question.
I'm thinking, and this is off the cuff, guys.
Yeah.
I'm thinking that guardian would sign as guardian of Billy.
Yeah.
So they're going to be somewhat on the lease already. Billy's going to be your tenant. That would require more of a tailored lease, I would think, just now thinking off the cuff. I don't think you can use your standardized lease. I think that's going to require some additional language.
Yeah, and depending on the facts of what you're asking too, if it's a court-appointed guardian for a legal adult that is incapacitated, if they're signing a lease agreement as guardian for that person, but they're not necessarily going to be living with them because maybe they're in housing, I don't think they would necessarily be listed as an occupant either, because unless they're actually residing there. So again, to your point, I think you'd almost have to tailor that specific lease agreement, or at least if you're being presented with one to sign, I don't think I would recommend signing just a standard lease agreement without making sure that the language is correct in there.
Yeah, I would agree with what's been said. I mean, if that person's not living there, the whole reason for the guardianship is to be able to review the contract and to make sure that it's acceptable for the person they're in essence representing, since they're incapacitated. So because without that, and this person signs it, and if they sign the lease without, say, the guardian's knowledge, and all of a sudden it's like, whoa, they come to court, that's going to be an issue there to litigate.
Again, I'd like to say that was a good question. I've never heard that one before.
That was a very good question.
If a tenant damages beyond normal wear and tear a new appliance, and I replace that appliance with a used appliance, do I charge the tenant at the damages hearing for the cost of the new one or the used one?
You charge them what you paid for it. So the purpose of damages is for you to be made whole, not for you to make money off the tenant. So if you go and you buy a washing machine at a discount store and you buy it for $500, that's what you're going to be charging your tenant. You're not going to be charging them the $900 one because that's one you could have got. So again,
I have a house. I put a brand new stove in. 6 months later, that stove no longer works. Maybe they did it, whatever. I get them a used stove. When I go to damages, can't I charge them for the new stove because that's?
I'll get a little bit more with the question.
I was
Okay.
what she just said just now, that was the intent of my question. This has actually happened to me. I had a friend of mine from high school rent a house for me. I gave her a brand new refrigerator, brand spanking new. She invited a bunch of cats into the house without my knowledge. Fleas went everywhere. Bees went in the refrigerator. They started multiplying in the refrigerator. The refrigerator was damaged and beyond repair. I replaced it with a used one, but then I ultimately ended up taking her to court. I was told by this collections agency that was helping me that I should charge her for the cost of the used one, not the cost of the new one that I originally put in. Is that true?
So I would say this. I mean, as far as the court goes, we prorate. Okay, we look at, say, carpet. Carpet's been brought up, and I'll get to an appliance. So carpet has a 7-year lifespan in the court size. Okay, and we do there's a little formula that we do. How many months has a person lived there? When was the carpet installed? And all those things. If I'm the tenant and you're the landlord, I move in, and you can show this is where evidence, documents that Amy talked about earlier is important. So I would say keep your receipts, keep your, anything you have showing when you bought these things, because that's a question that the court will ask. How old is this appliance? Well, I bought it right when they moved in, right before she moved in, and here's the receipt. Then the court will say, okay, well, how long, we'll do that later, right? How long was she there? How many months? And we'll do the math on that. I don't think it's unreasonable to say, hey, she damaged a brand new refrigerator after 6 months or 3 months, whatever it was. And in addition to that, I had to go and buy a new used one. Now the question would be, is that new used one, is that damaged too or not? If that's not damaged, then there's no damage to that, but definitely your new one, because you're out. I mean,
okay.
And that goes for linoleum. Since I'm on this topic, I mean, linoleum, tile, flooring, ovens, washers and dryers, you name it. In the court, we do our best to try to figure out a lifespan that's reasonable for everyone involved to be made whole again.
Yeah, and anyone who, if you've worked with counsel attorneys in the past, and I always thought this was really entertaining because I'm a non-traditional attorney. I worked in banking and finance before going to law school. So I always found it entertaining when I was going through school, and the terms that always seem to come out of attorneys' mouths are reasonable and it depends. And I thought, in banking, finance, it's pretty black and white. Surely this is just some sort of rigmarole, or scam that people are trying to use to get more money for their business. And I've been very humbled by it because, you know, the black and white is the law, right? So we can look at Indiana code, we can look at statute, and we can give you very relatively clear and concise answers on that. The it depends and the reasonableness comes into when we are lacking documentation, when we're unable to prove things, or when, you know, and we're really coming down to just relying on what he says, she says. And so that, again, if you ever hear that from an attorney, don't take it personally, or don't think that they're just trying to push you off. It really does just depend, unfortunately, on the specific circumstances, and then what information do we have that we can really advocate for you.
Nicely put. What if the tenant refuses to pick up the certified mail with a 30-day notice?
Well, okay. Get it all the time. You're sending your 30-day notice certified. What I would say is send it to them regular mail too. As long as it doesn't bounce back, you have a reasonable belief that they got it. I send every single document that I send out of my law firm, no matter what kind of case it is, certified and regular mail.
Same.
I would also add, it's also a very good practice to actually post the notice to your tenant's door in an inconspicuous spot, so when they come home from work that day, they can see it sitting on their door right there, ready for them.
And one more thing I neglected. Let me just wrap up my idea so I'm not leaving a glaring hole here. When you file evictions and when you're filing court documents, good service is having your process server deliver it to the house and then put a copy in the mail. That is good service unless proven otherwise. I know Magistrate Douglas is looking at me like, say otherwise. Unless proven otherwise, that is good service. So again, regular mail's fine.
Yeah, from the court's perspective, I keep saying from the court's perspective, right? Yeah, I mean, if they don't get their mail, if they don't sign for the certified mail, the fact is that you're sending it to the last known address, which is the rental. Because if they're not there, then the question is, did they vacate? Did they already leave? But yeah, you come in and say, oh, this is where documentation comes in again. I would always say make a copy of the letter, show that you sent it certified mail. When I was in private practice, if it was something like this, I would have a copy of the letter, I'd have a copy of the green card, and that way when I come to court, I just give it to the court. Say, here you go, Your Honor. It's those sort of things that the court's not going to really balk at that because you did send it.
Can you seek damages on a land contract after eviction for non-payment?
I'll take this one because I've been doing a ton of these lately. Let me unpack that. Can you seek damages on a land contract? Can you give me
After eviction for non-payment.
Well, first of all, you can't evict on a land contract. So let's dispel that notion right here, right now.
Nope.
So no. What you're filing instead in lieu of an eviction is what's called a complaint for surrender of the contract, or in the alternative, foreclosure of the contract. What you're doing there is you're filing that in regular court, not in small claims court.
Plenary court.
Plenary court.
Big boy court.
I didn't say it. She
Big,
said it.
big boy and girl court. That's
It is
fine.
big boy court.
I'm in front of Magistrate Douglas tomorrow. I'm not going to say that.
Mr. Benderly, motion denied.
I think I am next week. We're
Yeah.
good.
So you're going to file that in regular plenary court. And you're filing that there because the court's going to make a determination on how much equity is in the home.
Yeah.
Every single one, if you use the standardized form, that says substantial equity is 15%. Now, I will tell you a dirty little secret here, guys. The court isn't going to, the 15% is not bright line.
No.
So that's why you file those things in the alternative, because if the court says, look, they don't have substantial equity, well, then they do surrender the contract. But if the court says, look, it's 11%, I think that's substantial equity, Then you've got to go through that process. It's a little bit different. So that is a much more involved court case. Evictions, Magistrate Douglas, what 45, 60 days
Total?
for possession.
I mean, it can be.
Yeah.
It can be.
Those land sale contracts, 6 to 9 months.
If everything works out.
Yep.
So get an attorney.
Yeah,
Absolutely.
right.
And so,
100% on that.
so the court, small claims used to do land contracts for evictions. And the court, we would decide substantial equity or not. But there was a case, and it's a lot of gray, this issue, there's a lot of gray in it. And so the 4 civil judges and the 3 small claims magistrates got together and said, what's the best procedure for this? What's the most economic for the parties and the most streamlined, even if it's 6 to 9 months, the most streamlined process versus bouncing people around. And we've come to the conclusion there was a case law earlier in the year that came down from the Indiana Court of Appeals that suggested, not a bright line rule, but it suggested that land sale contracts, small claims doesn't have jurisdiction for that. So we took that, discussed it, and we, Allen Superior Court, made the decision that, as Jake and Amy were discussing, that land sale contracts are in big boy, big girl court.
And if you're an LLC or a corporation, you can't represent yourself.
Mm-hmm.
Okay, so then you especially need it.
Yeah, land contracts sort of get the little like heebie-jeebies because I regularly talk with clients who, again, have for years dealt with land contracts. They have them sort of in that same bucket as eviction and think, oh, I can just go out. They have no understanding of what substantial equity even means or what that process even looks like. And boy, when we went through COVID and sheriff sales were shut down and we're just trying to figure out how to keep things going, and we have tenants not paying and landlords are just carrying that tremendous burden, that's when you really realize that land contracts can be good. But just keep in mind, if you do have those in addition to traditional lease agreements, you're literally taking on the position of a financial institution like a bank. You are the bank, and that's just something that you need to kind of put that on. That's your role, and that's why it's so incredibly different in the process.
Yeah, you're more akin to a mortgage foreclosure than you are an eviction in that circumstance.
All right. If a tenant wants to sign a residential lease as a corporation, so instead of, Wildwood Apartments is renting to Shirley Rourke, it's Wildwood Apartments is renting to Shirley Benton. Can they do that? Or can I say, no, you sign your name because it's written on your ID?
Don't do that.
Don't do that. Please don't do that.
See, I guess you could.
Yeah, you can do anything
The
you want.
question would be why, right? Why and
We have situations quite often where a landlord will come to us and they had a corporation signed on behalf as the tenant. If you have a corporation sign, you need to get somebody else's signature to go along with that. And it's really not as big of an issue at the eviction portion of it, but when you get to the damage hearing, that company could be dissolved. Who knows where that company is at that point? It's really hard to collect on a company sometimes to garnish their wages.
I would say in the vast majority of commercial leases that I prepare, I always have a personal guarantee there too. Mm-hmm. For every rule, there's an exception. Not every one of them, but even in commercial leases where it is a company leasing, I'm still having somebody on the hook individually. For residential, I don't see why you would ever want to do that.
Yeah. Are you allowed to deny it? You can flat out say no.
Yeah, you have the freedom of contract. Absolutely.
Can you send certified mail to a P.O. box?
I don't think typically they accept them. No.
because you have to have somebody sign for it.
Right. Somebody's got to sign for it. So generally, I don't know that I've ever had one.
It might be better to ask the post office.
Fair answer. Is it unreasonable to charge a $50 late fee to a tenant who pays a small portion of the rent as an example, Fort Wayne Housing Authority pays $700 a month and the tenant pays $25 a month.
So the general idea is that late fees are understood to need to be reasonable. So the court often will have an understanding of what reasonable is and what percentage of the rent per month you can have as late fees. So if you have like, $600 rent per month and you charge $300 in late fees, that's going to be too much. But if you charge like a $60 fee, that might be fine. But that might change depending on that very much might change court by court on how much that is. But I've seen usually around 10 to 15%. But I'm actually unsure where the court is currently on that.
So late fees are considered in the lease liquidated damages clause. And the way the court looks at that, I mean, you're free, as Jake said, you're free to contract. You can put in there a late fee $1,000 a month if you want to. Now, the question always is that if they pay it, great. But if they don't pay it and you come to court and then you're asking for that $1,000, as an example, the court's going to look at what the liquidated damages clause says. And as Andrew pointed out, it's been the court's historical perspective of anything above 10% of the monthly rent is deemed punitive, or as the law says, penal, because liquidated damages clause is to compensate the landlord for waiting on delayed payment, but it's not supposed to be harsh, extreme. And so sometimes we'll see so if you see one of my orders or one of my colleagues' orders, it'll say in there, we find this late fee, whatever it is, $25 a day, every day until the rent is paid in full, and if not, an additional $150 tacked onto that, or whatever it may be. The rent's $500 or $750, and all of a sudden the late fee is more than the rent. You're going to see at least in my order, it's going to say that's unreasonable, and the court historically caps those at 10%, which the court has found as a reasonable fee. So just keep that in mind. And like Perry Law Office and a lot of landlords that use attorneys, they just put that in the lease. At least in Allen County. I don't know what they do in other counties, but at least that's what I've seen.
Can I clarify that question a little bit? A lot of times I've had cases where they might be receiving a portion of the rent paid for by an agency like Brightpoint or Fort Wayne Housing Authority, and maybe the tenant's only responsible for $5 or $10 a month. Mm-hmm. And so the tenant makes a calculated choice to say, I don't think I'm going to get called out if they're getting $700 from the agency and they're missing out on my $5.
Can I
Is
ask
it still
something?
reasonable if the housing authority is paying that portion and the tenant doesn't pay? Is it reasonable to charge the full late fee because the full amount of the rent wasn't received?
Let me know if I'm wrong on this, because I've been a landlord with Section 8 vouchers, I've been, etc. So regardless of who's paying the rent, whether it's housing authority or Brightpoint or Wayne Township, it's the tenant's responsibility to ensure the rent gets paid. So it's the tenant's responsibility to pay any late fees, regardless of who was late. The late fees are their responsibility.
Well, asterisks.
It depends.
So and this might go more into the fair housing sections and all that, but for instance, if someone's on Social Security and their payments, they always get paid on the 3rd, and that's always happening, and they ask you, hey, it's always going to be on the 3rd, can you please change that? That might be different. That might be somewhere where you can't have that late fee charge, or if you've been accepting the rent from that agency every month for like a year, and suddenly you say, oh no, I'm charging you late fees now. Maybe that can't happen. So there can be some exceptions to that if there's a pattern or if there's a reasonable accommodation or something like that. But generally, yes, you're responsible for your late fees.
Yeah, I would say generally that person would be responsible unless it's one of the asterisks. So yeah.
Also, I feel like this is a good opportunity to asterisk footnote Magistrate Douglas's comment. Because you made a comment about like $1,000 late fee, for example. Don't think, and I hope you don't think this, but if you do, that just because when we were talking about the contract has authority, the contract speaks, and that's our evidence that we're going to provide, that you can put anything in there, and that it's absolutely because it's in black and white and it was signed by all parties and it was agreed to that it's going to happen. I've even seen contracts, and I hate to admit it, but where literally an attorney has put in certain terms because that is what their client wanted them to do. And it's just not gonna hold up, because it's not reasonable. It doesn't comply with the law. It doesn't whatever. So if you are drafting your own contracts and you do have that experience, or if you do seek counsel, good counsel, part of their job is to let you know, unfortunately, the things that you may not want to hear. Maybe you do want something in there and we can write it in there, but there's not necessarily going to be a guarantee that you're going to get it, because ultimately, and unfortunately, you're not going to know that until the day comes that something goes sideways and now you're fighting in court about it and it has to go before a judge to make that ultimate decision. So just keep that in mind too.
Right, that's right. And that's a good asterisk, because you have the freedom to contract, but it can't violate the law. It can't do those things too, right? So this is a lot of stuff to keep in mind, but do your best.
Did that answer to the best? Okay. Does evidence for damages, example pictures, have to be printed, or can a flash drive be brought for the images here?
Very good question. So damages, obviously everyone knows, or at least are just going to find out here, you can't bring your cell phone into the courthouse. And so what the court is telling people is, if you want to print, preferably pictures, I'll just say it in everything: pictures, texts, posts, things like that. You can print hard copies and bring those in, because we're going to ask, hey, do you happen to have a copy? Give it to the other side, because everybody has the right to see what's being given to the court, right? But like video, audio, we're asking people, litigants, to put it on a USB drive. And what's nice is the Allen Superior Annex building, at least the courtrooms, are getting a little facelift. We're getting large screen TVs installed on the wall. We're getting an Elmo system. For those of you that don't know what that is, it's a little center where you can put a document underneath and project it up onto the tip television. We're also having USB drives that are going to be on the bench. So if you do get one of the judicial officers a USB drive, I can plug it in, project it onto the TV, and we can go from there. So we're advancing here in small claims court. So to answer the question, you can put it on a USB drive. You can print things out. Just know, though, that it's going to take more time if you just give me a USB drive and give the other side a USB drive. If you don't give, either way you do that, you're going to have to plug it in, and the other side's going to have the right to look through those things kind of first. So that's going to delay the hearing a bit. And from the court's perspective, we would prefer not to delay if we can. And that's just as another side. If you're coming to court with like a stack of photos, that's great, right? That's good evidence. But maybe before the hearing, either give your copy to the other side instead of waiting until you're presenting your case, because then the other person's going to say, Your Honor, can I take a look at these first? And it's like this, and that just takes more time. And as you guys know, your hearing's set for a half hour, right? So it's 15 minutes apiece, which goes by pretty quickly.
So if I do bring a flash drive for my hearing, when I come in, I would let the sheriff let me walk through with it, or I would hand it to them?
Nope, they'll just they're going to have you empty your pockets and whatever else, and just have it out. You can put it in the bucket. They know, well, we've told them that. And what I would also ask is to, when you check in with Annie, the receptionist, or if someone else is covering, let that person know. Because what happens is that when you check in and say, hey, I have a USB drive, like right now, I don't have a TV in my courtroom yet. None of that stuff's set up yet. It's in the process. But we do have a rollable TV with a laptop on it that we can roll from courtroom to courtroom. But that takes some time too. So we just ask that when you check in with the receptionist, let her know I have a USB drive, and that way when she calls up to the court reporter or the court and says, hey, this case is ready, and by the way, they have a USB drive, then we can make sure that TV is all set up, good to go, so we cut down on wasting time. And I don't mean just for the court. I mean, you guys, we know you guys are busy too, right? And we want to be conscious of your time, plus the tenants, plus ours. So yeah, just let the receptionist know.
Yes. Logan, this one is for you. Could you discuss a little bit junk fees?
Oh, okay.
Is it in your hand?
Junk fees is a bit of a confusing term. What junk fees actually encompasses and what we're kind of finding they're encompassing is those admin fees that a lot of landlords are charging in order for the landlord to process a payment or to do some random thing that their tenant would have to do. Those right now, you can generally still charge for those, but it is, I think it's the CFPB that is going to be looking more into those. That's the Consumer Financial Protection Bureau. I believe it's them. Another thing that's kind of a part of this is they're going to be cracking down on advertisements. So let's say you own a home and you advertise that your rent is $800. Well, your neighbor also advertising their property says it's $900. They're obviously going to go to you first since yours is $800, it's $100 cheaper. Well, they get there, they sign a lease agreement. It's not $800 anymore. It's $800 plus a $20 monthly parking fee, and this fee, and this fee, and this fee. Oh, well, now the rent is actually $1,100. That's something that they're going to start looking at as well. So the best way to protect yourself as a landlord is to make sure first you are upfront with your tenant about every single charge that they're potentially going to have during the month. Second thing is you should make sure those charges are in their lease agreement or an addendum. That's what's going to probably be the best way to protect landlords when this finally does roll around. Is just make sure that you are very clear and concise with your tenants regarding what they're actually going to be charged each month.
Thank you. Jacob?
Either way.
All right. What are some of the most common mistakes you see landlords make when it comes to the lease?
Well, the answer is selfish. The answer is the attorney fee provision. It's selfish because that's the first thing I look at in any contract I ever see. It's also selfish because when a landlord is coming to me to help them, they don't want to have sunk costs with me that they're never going to recoup. So that provision is either lacking or it's worded so poorly that I know I'm not going to prevail on it. So that's number one. Number two, I think with most landlords I represent, everything goes great until we get possession. Where I find there's been a disconnect is proving up those damages and not having good evidence. I think I do this fairly well, but I'm not going to be successful if you guys don't give me any proof of your damages. If you just go in and testify to Magistrate Douglas or any of the magistrates, well, he put a hole in the wall. All right. Even if that's true, we don't know what it costs to fix it. We don't know anything like that. So really papering your damages is the number one issue. That's not the least. I just realized I didn't answer the question. The number one, honestly, the number one thing I notice is getting a form from Rocket Lawyer or NOLO or any of the other places that we curse on a daily basis, because you can see those immediately.
It's gonna be like chat
that,
GPT
yeah,
text.
you can immediately see it. And I'll ask a tenant, why is the forum selection in Idaho? I don't know. I didn't read it. Read your own lease. It's your lease. So, I mean, attention to detail and that stuff, I think.
And we laugh about that. I see it all the time too. it's like this. We will follow the laws of Michigan. Is what I feel like. That's a very different.
Nobody wants to go to Michigan for their Indiana lease agreement.
And maybe not so much in the landlord tenant, but I can tell you guys for an absolute fact, I had a mortgage that somebody did that on and did a really bad job of writing their own mortgage and said it was interpreted per the laws of Texas. And I believe it was Judge DeGroot literally started researching the laws of Texas, and every attorney on that case had to research the laws of Texas. So it cost a ton of money. I had to learn a little bit about Texas law. And honestly, it was a simple oversight that cost that person a lot of money.
Thank you. This one, Magistrate Douglas. What is the limit for damages in small claims?
Any small claims case, including landlord tenant damages, is $10,000.
I say that because I know a tenant who had $20,000 in owed rent, and we assisted him, and he couldn't think of only been awarded 10.
Right. You can claim, you can file in small claims and say, I have $20,000 in back due rent and damages to the property beyond normal wear and tear. And you can come into court and you can present that exact evidence, and the court will find in my court order that you've presented evidence and the tenant owes you $20,000. However, under the jurisdictional limit in small claims, it's going to be reduced to 10. So you can come in and claim any amount, and that's fine. We're not going to stop you from doing that. It's just what is the amount of money that the judgment is going to be for is $10,000.
Magistrate Douglas, the jurisdictional limit for LLCs and corporations?
10. Any case is 10 in small claims. Now, so if there's $6,000, if it's $6,000 and you're a company, you have to have a counsel with you.
Why?
As a company, because that's what the Indiana rules
That's
of
the law.
small claims court says.
That's one of the black and whites.
I'll give a plug for that. Please, I know it's boring or can be, and tedious, but I would recommend everyone at least take a look at or have access to the Indiana rules of court small claims. It's on the website. It's out there. Local rules too, because it will save you time and money.
Yeah.
Because I will tell you, you can't represent your company or whatever it is. And that's where paperwork, I'm going to do another little plug here on the proper paperwork too. Your business verification of ownership, certificate of compliance, where it's showing that the owner of that property has given you authority to represent the organization. Because if that's not there, chances are we're going to say we can't proceed today. And we'll continue the case once, but after that, we'll dismiss it. Okay? So I know that may sound harsh, but we have to go by the rules too. And so I just make that little plug.
Just because I feel bad when this happens, but if you send an employee to the small claims court for an eviction, make sure that you filled out whatever proper forms there are for that employee to be there. Make sure they're a full-time employee, or it gets very awkward very quickly, because then if we're there, for example, say, well, we wish to dismiss or have this continue because that isn't the right person who needs to be here. So to just protect that employee, just make sure you do look up those small claims rules and follow them. They'll make it a lot less awkward at the hearing.
On that phone, also, the local rules have been mentioned a lot tonight. Probably still will be the rest of the night. At the bottom of your handout, there is a link that takes you directly, type it in, takes you directly to the local rules.
And just as, I know I keep preaching, please review, but the small claims rules were updated and made effective January 1st of 2022.
Yeah.
I just want to point out, and I'm just going to read this real briefly here. A statement that a court may sanction a designated employee or trustee and the entity the employee or trustee represents for failure to comply with these rules or local rules of court. Okay, so if you come in and you're not complying, sanctions may include assessment of court costs, or reasonable attorney's fees, the entry of a default judgment, the dismissal of a claim with or without prejudice. And if you don't know what that means, with prejudice means you can't ever bring that case up again. And or incarceration. Okay, so the Supreme Court has said these are very important. Please follow them. And so if you do come into court, or if I have maybe said to you, you can't do what you're wanting to do, that's why. And I'll continue it out once, we'll dismiss it. But just remember in the back of your head, incarceration means jail, right? And obviously nobody wants to do that. And that's just never, I don't want to say never, but I can count on one finger how many times I've had to do that. And that wasn't for not completing the proper forms, okay? But I just pointed that out because that's new as of January 2022. So just keep that in mind.
I always think women ready to say something.
It's easier to pick it up every time.
I do have a question for you. What information is required to be added to leases? As an example, lead paint, fair housing.
Yeah, there's several required disclosures. The first and the most common that most everyone knows is the lead disclosure. I know I gave Becca a few copies of what a lead disclosure could look like. That's from the U.S. Environmental Protection Agency website. If you type in lead disclosure, landlord, you're going to get taken directly to that website. There's an addendum and the actual lead document, or the instructional booklet that you can hand out to your tenant as well. I know for head leases and the ones with rental assistance, there are other requirements. If you have a lease like that, if you're on one of those programs, you're going to need to make sure you have like your landlord tenant addendum for like Section 8. VAWA, the Violence Against Women's Act, is another one that's typically required for those. Pursuant to the statutes, 323138, you're required to disclose the manager and agent for that tenant so that they can make sure that they know who they need to reach out to. It needs to be in your lease agreement. Something that we actually found a couple years ago, if you are in the floodplain, you are required to disclose that as well. If you know that you have knowledge that you're in the floodplain, that's a requirement. Something that happened, I actually just found when I was looking up the answers for this. Just this year, there is a new disclosure for landlords. 21.1 disclosure of property near a military installation. So if you were in 3 miles from an installation, you have to disclose that now in your lease agreement. Like I said, that's brand new this year. I didn't even know about it until I went and looked this up. Water and sewer utilities, all utilities, truthfully, you provide utilities for your tenant or they are paying on it. You should have this actually taken care of well before your lease agreement is signed, but disclosure of the utilities the tenant is going to be responsible for, along with the documentation for that. Fair housing, it's not a required disclosure to be inside your lease agreement. However, you should have some sort of fair housing disclosure in an application that the tenant would be filling out. You should also, if you have a place where a tenant comes to sign a lease agreement, to work with you, you should have a fair housing poster. If you go to HUD, you can usually get most of these documents for free. I would highly encourage, if you don't have one of those, to get one of those. It's pretty important that you have that as well. The last thing is smoke detectors. You have to, there's special statutes that use it. 2211 18.3.5. You have to disclose that your smoke detectors are working. There are specific requirements for smoke detectors in a home where they're supposed to be. Violations of that specific statute could result in liability for you as a landlord. So I would encourage you to also make sure that you have the smoke detectors as well. I think that was all I had.
And on the back table where everybody signed in at, there are a couple copies of the lead document that Logan was alluding to. If we run out, you can just let us know. We'll make sure that you get that copy. You can reach out to Health department. That is not right, and they will mail you lead brochures. I feel like that's wrong. I get them from them every year. I believe it's the health department. They will literally mail you the lead brochures, and they have it in Hispanic, and they have it in Burmese, and you can also, I believe, go on their website and print those off.
And Shirley, I printed out from the EPA.
EPA? Okay.
Keep your family safe. EPA.
Okay. This one, Magistrate Douglas, if you could give 3 pieces of advice, what would you tell them?
Well, I think I'm gonna say it one more time.
Drive it home.
read the rules. All seriousness, read the rules. Know the eviction process. And I know we're not covering that today, but obviously this is your business. And running your business, you got to know that process. You got to know every step of it and know what you need, right? And so, believe it or not, the court staff is here to help, meaning we can point you in the right direction. We can't give legal advice. My staff can't give legal advice, but they're really good about trying to help the best they can without giving legal advice, right? Pointing you in the right direction, just neighbors. We're trying, Indiana Legal Services, all the things that we're now having at the courthouse, the eviction facilitator position, just information that we feel is important to landlords and tenants. So number one, know the rules, know the eviction process, and be prepared. Okay, be prepared. I can't understate that. That might be number one, right? And that encompasses knowing the rules and knowing what to file and all those things. Because if you're not prepared, as has been pointed out by the rest of the panelists here, you may not get what you're asking for in court. And it has nothing to do with you personally. It has nothing to do with anything else other than, did you show more likely than not, or by a preponderance of the evidence, 50.001%, that you're entitled to something? And if you don't have some proof to back that up, I have no choice but to not give you what you're asking for. So be prepared. And if you need help with being prepared, you got some qualified attorneys. And I'm not just saying this because I'm sitting next to these gentlemen and lady. They're very good at what they do. Okay, I'm not plugging them for you to hire them or not. I'm just saying I'm glad they're here. They do know what they're talking about, and they have been in the trenches, so to speak, and can give some good guidance.
Did we record that? I'd like to take that.
Before we begin our final little wrap up, some of our other teammates are going to begin handing out evaluations. I would greatly appreciate if you would fill these out, because this is how we decide what info to share in these sessions, what kind of sessions to have, and how we're doing for them. So while they are handing those out, are there any last remarks you guys would like to leave us with? And I would like to, again, thank all of these people for being here free, because we know invaluable information.
Just thank all of you for being here. I mean, frankly, this is a great turnout. And thank you for being here, and thank you for listening to all of us talk.
It was kind of rough in the beginning, wasn't it? A little bit of too much gray.
So I would share just one last thing that I've seen. It haunts me to this day. There was a hearing. I think 3 of us here were there. But there was a debate about a ledger, and there were 5 different interpretations of the ledger. The 2 attorneys, the tenant, the landlord, and the magistrate. Keep good record keeping. It's just and double check it before you come to court. The jokes about lawyers, unless you're a tax attorney, kind of run in the direction of, we didn't go to law school because of our skill in math. But not always true, but just keep that in mind when you're going to court, or just generally that you are keeping constant updates to your ledger.
Yeah, I want to second what you just said, partially because I was that attorney that was also involved in that. But it's very, very important to document every single last thing you do, no matter what it is. what we tell everybody, if you talk to a tenant on the phone and it's about a conversation that could go two different ways, you should write to your tenant after that conversation, hey, we talked about this. This is what we discussed. Especially if you're making some sort of agreement or a settlement, and it's going to be invaluable for you to spend that a little bit extra time to take that moment, get that stuff documented. It's going to help you in the long run. And secondly, document. And third, make sure you send your 14-day abandoned property notices. That's my biggest thing that we see in our office, especially recently. Make sure you're doing that. It's required. You send a letter out, registered mail, or regular mail. I don't know which one it says on the local rule. But make sure you do that because it will save you a lot of headache and a lot of time and money as well.
Just review your leases. Even if you think you've got a great one, take a look at it tonight. Take a look at it over the next week. And pick it apart as if an attorney's going against you and looking at it. I mean, I'll tell you guys, I've been doing this for 10 years. I look at some of the ones I did in the beginning, they stink. And it's a process. And this is your business. And approach it that way and approach it as if somebody on this panel is going to be looking at your lease and we're going to be trying to pick it apart.
Yeah. I want to take my moment and just give a thanks to Becca and VLP. And if you're not familiar with, Volunteer Lawyers Program, and please, when they are handing out the surveys, if you have any feedback that you'd like to give, maybe we didn't cover a topic thoroughly enough, maybe there's some other topic that would be really helpful for you, I would encourage you to please be as, honest and transparent as you possibly can on these, because this is the first time we're doing this. I'm really honored to be part of the panel. I know if I were sitting in your shoes, I would be particularly excited to have heard everything Magistrate Douglas had to offer tonight, because that's the day, that's what I would be here for. Am I covering everything I need to cover? Do I really need a lawyer? And if I have that bad day where I've got to show up in court, whether it's by myself, representing myself, or whether I have an attorney with me, what are the judges looking for? So I personally am really excited that they're putting this together. I know it sounds like, there's that connotation that lawyers just want to make money and, a good fight is good money in our pockets and good billable time. But ultimately, especially as Magistrate Douglas commented, everyone I know that's here at this panel, we genuinely just want to see how we can best serve our community and make sure that we can find good resolution for everybody. If you have to go to court, I hate to say it, that's when it's real bad. And so if we can figure out ways to help everyone figure out how we can work together to avoid those situations, that's really what we're here for.
And she wonders why she's on the panel. Before everybody leaves, we'd like to say again, this is the first of 4 sessions. The second session will cover fair housing, and at that time we will have Metro here doing a presentation, and you will be given a certification showing you completed fair housing training. The third session is going to be about programs in the area that may help your tenants with rental assistance or other areas. We're going to have Brightpoint, we're going to have As Much Ministry, we're going to have 2 different township trustees. We're going to have Just Neighbors. We've got so many people coming. It's going to be a lot. And then the 4th session is going to be about tenant and landlord relationships. And then we are also at the very tail end of that 4th session, we're going to cover whatever you guys let us know we didn't cover. Because we want to make sure that you're getting as much out of this as we want you to get. So again, thank you everybody. Thank you to our panelists. And you guys all have a good night.
Thank
and
you.
if you don't
Thank
take
you.
the candy with you, I'm taking it home.
Alright.
Just for